Oi, oi. Welcome to a Diary of a HR Man. Diary of a HR Man is brought to you by me, Omar Rashid, aka HR Man, where I open up my HR diary of over 15 years experience. The purpose? For SME business owners to resonate, reflect, learn and get guidance on their HR and people problems. So sit back, relax and let's get right to it.
The HR Man.
Hey everyone, welcome to the next episode of Diary of a HR Man. Bit of history today. So today I have my first ever guest and she is Neelam Afzal. Hi Neelam.
Hi, morning Omar.
How are you?
I'm very well, thank you. I want to ask a question though. What's the history?
History of what?
Because you said a little bit of history at the beginning.
Oh come on, the history is that you are the first guest on
Right.
Diary of a HR Man podcast.
So you look back at this after 100 recordings and it's like, oh, Neelam was my first guest.
Well, my first landmark is going to be 20 recordings.
Okay.
So I've done a couple of recordings where it's just myself. So I thought I'll mix it up a bit, have a few guests, and yeah, man, chuffed to have yourself as the first guest.
Thank you for making me the first guest.
Good. Do you want to? So you're an employment lawyer.
I am indeed.
Yeah. Do you want to tell everyone how you got into the world of employment law? What made you be an employment lawyer?
I was going to say suits, but we're going to come on to that. No. I qualified as a lawyer in 2008. So that shows my age.
2008, 2008. Actually, I'd graduated by uni by then as well.
So
Yes,
I
okay.
actually qualified at that point. So did all the traditional uni, blah blah blah, and I then went on. I was actually not even an employment lawyer. I was I like to call it a litigation lawyer, but in brackets, a personal injury lawyer.
Okay.
Yeah.
So one of those don't delay claim today.
No, I can tell you some stories, but not quite.
Okay.
They were accident management companies. So what would happen is they would pass the claims to the PI lawyers and we would deal with the injury claims. But I was really lucky that I had really good claims, like 6-figure settlements. So and I actually went to Sweden on one of the cases. So real great exposure. But then there was all these changes. So in 2012, the government, 2011 I think, they tried to scrap all the fee structure because PI lawyers and accident management companies were earning a lot of money in that point, like in that period.
So are you to blame for all the insurance claims and the premiums and the renewals going up the roof sort of stuff?
No, I don't think I'm personally to blame, but I think that yes, there was an impact because when I came into this industry, and I actually started in this industry around 2004. And I did see a lot of insurance companies just signing off checks left, right, and centre. I won't even tell you the kind of figures in 1 week that we collected in checks, and that's what the insurance company used to do. So there was a lot of money being circulated at that time, especially in like things like hire, personal injury claims, repairs. So it was people were making a lot of money at that point. So the government decided, quite rightfully so, I think, to scrap that process, and I knew at that point it was time to get out, and it was the perfect time. So my employer, who I qualified with and did my training with, great guy, he suggested a new area. And employment law always interested me. I did it in my LPC, so all the cases are different. There's a lot of scope around different areas. It's not the same. It's not process driven. And I went off and did my master's and became an employment lawyer. And that's where the story started. Not quite ended yet.
Okay. Now, your story so far is you've now become a partner
Yes.
for an award-winning law firm in Alum Rock.
Not Alum Rock. Come on. Omar, I keep telling you it's B8. It's actually Hodge Hill.
What you got against Alum Rock?
Look, I've had nothing against Alum Rock.
Are you
It's,
Alum
Alum
Rock?
Rock have got some of the best foodie places.
Are you Alum Rockist?
No, I'm not. I'm not. Okay, I don't know. It is actually Hodge Hill. Alum Rock's an amazing place. Look, all of our clients are largely from, not all, some are from Alum Rock.
but your B8 is...
B8 actually is Hodge Hill. It's like, I'll give you an example. Do you know my home, right? A lot of people will say it's South Yardley, right?
Right.
So it's B26. Now, I mean, obviously, if any of your listeners who hear this want to disagree and send me some evidence, but B26 is South Yardley. It's the same. B8 is Hodge Hill. So, but when people say Shard End to me, I'm like, nothing's wrong with Shard End, but it's not Shard End. I didn't buy a house in Shard End. It's like, I go to work. I don't go to work in Alum Rock. I go to work in Hodge Hill. That's my logic.
Okay.
Yeah?
So that's your reason for not saying I'm a named partner at a law firm in Alum Rock.
No, I would say I'm a named partner at a law firm which is award-winning in Hodge Hill, which is near the Fox and Goose.
Okay. What is the name of your award-winning law firm?
So it's called Wildings Solicitors.
Okay. Now, you touched on Suits, right?
Yes.
Now, in lockdown,
Yes.
I started watching Suits. I binged on Suits. I actually finished all of the episodes of Suits in probably about 3 weeks. That's how much I really, really got into it.
Yeah,
so
I'd say the same.
Yeah, so a couple of questions.
Yep.
That's my first exposure of, let's say, the legal firm. Now,
Okay.
I'm guessing it's been kind of dramatized, but how close to reality is the law firm, the law game, to what's been shown on Suits?
Okay, so look, there are parts of it that are reality, like the busy office. You know, you've got different types of styles of lawyers. So, I mean, like, my old firm down south, I would say, resembles some of it. Like, my boss, who was a very litigious lawyer, so, you know, he would want to win the case. You know, when you have a conversation with somebody on the phone would go down and it was, you know, slammed down, and all court cases and, like, coming out and winning cases.
I found it sometimes...
But it was over-dramatised.
Yeah, I found it sometimes... You weren't lawyers, you were like police detectives. Some of the things you'd go into, look through, and...
But well, that's what you do as well. You see, look, okay,
Yeah.
I'll let you into a secret,
Go on.
right? So, a lot of people say that if I didn't become a lawyer, I should have become an investigator.
Okay.
Okay?
Yeah.
Now, a lot of my close friends who know me very well know that and I probably shouldn't say it because it sounds a bit stalkerish, but if I was gonna look into somebody and find out any detail or find out anything like I wanted to, I would know what steps to take to get there.
So you know the stuff like, so every time there's a case on Suits, they would like subpoena the other. So what's the English? That's the is that still the English word for? I thought that was an American word.
It is an American word.
Yeah.
I would say witness summons.
Okay, so would you do that here? And then
Not-
you go through reams of emails. You go reams of case
But
files,
we have
cases.
disclosure. So what we have here. So it's like see what they do is they witness, and this is my understanding, is they bring the witness in, they record it all under, and then they question they go through the person's, they question the person, but we do that in the courtroom.
Yeah.
So, but that evidence, we do it by a witness statement. They simply seem to do it by bringing the person. I guess it depends on case by case. So Suits were showing large cases.
Yeah.
You know, Suits were about the big cases, the money making. You know, the corporate cases. Whereas we have cases here, it's witness statements. Then the evidence is given in the hearing, and we have disclosure. So we have the same reams and reams of emails, except we have them in disclosure. So we have different names for it.
Okay.
Yeah.
If you were to describe yourself as a Suits character, what would you?
Okay, so I did this little thing yesterday, and it was not an app thing, online, and you do like 10, 15 questions, and it gives you your character from Suits.
Oh my god.
Yes.
Okay, go on.
So you go through like a series of questions, like what would you be like, how do you chill out, or how do you win, you know.
Yeah.
It was really interesting, right?
Yeah.
Answered all truthfully.
Yeah.
And I came up as a Donna. And shall I tell you the description that was given under Donna? So it says, there is only one of you, and you are indispensable. No matter how hopeless things become, everyone knows they can count on you to be there for anything and everything. resourceful and clever, you're Donna, and you have to take it to a whole nother level, which is true.
Donna wasn't even a lawyer?
But Donna's coming up. Look, there's my proof on my screen.
Okay.
But actually, I would say, if I had to say, my initial thoughts was a Ross.
See, I agree with that. Not in the sense of like, you're not a lawyer fake or sort of thing, but I'm on about he was very methodical, very logical, geeky, even you could say. A very good attention for detail, and I think from getting to having known you for a few years, and we've worked together on certain things, I would say definitely. Yeah,
I would say I am a Ross because. And I think my logic is I'm very logical.
Yeah.
I have to understand X and Y, why this is this, and reasoning behind some stuff. And I become really bamboozled when I can't put reasoning behind things. So it's like I'm very much a black and white person.
I think you'd be hilarious if you was a Lewis Litt.
Oh my, yeah, Lewis Litt.
Okay, wicked. Okay, look, let's get into the nitty gritty.
Mm-hmm.
So. It's fair to say, look, as an employment lawyer, your client base, correct me if I'm wrong, is very much SMEs in the main. Would you say that's...
It is, yeah.
Now, I did a little bit of research looking at the Ministry of Justice. They come out with, obviously, stats around employment tribunals and stuff. And the biggest reason for an employment tribunal is unfair dismissal.
Yep.
Now, obviously, that can mean a whole realm of things. Just quickly, what's your experience of employment tribunals? The biggest reason is, do you come across claims to defend, or even from an employee point of view, around, is it unfair dismissal, or have you experienced anything different?
So I did it from both perspectives, employee and employer, and what unfair dismissal is always going to be the largest or the bigger factor in a termination, because what employees tend to say is that their employment's been terminated, so there's your unfair dismissal. But then if there's any other reasons around it, like for example discrimination, whistleblowing, they seem to be secondary, because your unfair dismissal is your first tick. So when you fill in the ET1 form, that's your first tick, isn't it? Your unfair dismissal. Then you get your second boxes, or your boxes which follow for discrimination or whistleblowing. So I would say, because that first box 9 times out of 10 is going to be ticked, that's where the data is going to count from. So unfair dismissals are the bulk of the claims that we do get.
Okay. What do you think are good practices SMEs could implement from the outset?
Oh, okay. It's a very there's a lot. I mean, unfortunately, I think written procedures, for example, I still, and you'll be really surprised, still see businesses who don't have contracts.
Yeah.
Who still in 2021, they have, you go and see them and you say, okay, so where's the contract of employment? And they look at you like they don't know what that is. Or did you send them an offer letter or terms of engagement letter at least? And they look at you. So, the fundamentals are just to have all the paper processes in place. And I think we've heard this, and we talk about this so many times, that, contracts, handbooks, processes, even good practices like dialogue with your employees at the beginning when they start, that kind of relationship, so that you've got, if there's any concerns, they can come to you before things get out of hand. Delivering, even workshops could be good, or staff get-togethers are good, those kind of things. There's so many things that you can do to build those kind of relationships. So I think you've got to look at it twofold. There's the compliance, which is your paper exercise, and then there's the workplace itself and how you manage that with building those relationships. So it's twofold.
What about a situation where, okay, someone's employed at the start of an employment as X, but through time it's changed so much that X isn't, let's say valid anymore, but there's no trail of Y and Z, then doesn't that contract become a little bit irrelevant to show if it's 5 years, 10 years historic?
Yeah, I think what tends to happen is the fundamental terms in that contract generally may stay the same. Some of them may stay the same. For example, if they had some restrictive covenants that stopped them from competing or working, those would continue throughout. It's always advisable to refresh them because I've seen restrictions drafted so poorly and such a long time ago that that business might have evolved or changed. And what that business wants to protect now is now different to what they wanted to protect 10 years ago. The answer to that is yes, it does evolve. Yes, it's recommended that businesses, when they change someone's job title, to do a variation or a letter or put something on there. It might be after 15 years, somebody might want to refresh that contract. The contract has some validity because it's the number one to check your continuous years of service.
Yeah.
It's got some things in there that would still be relevant, like we talked about confidentiality, restrictions. But your holidays might have changed, your salary might have changed. I would still say yes, because I still ask for contracts when I'm doing settlement agreements. I still ask to see their original contract, even if it's 20 years ago, just to make sure there's nothing in there or any variation letters. So it is still valid.
What poor practices have you seen? Now, I know you touched on. I know you've touched on that there's hardly any contracts or procedures, but just generally, what poor practices do you see from SMEs?
Employers not managing sickness properly, not getting occupational health reports, knowing that somebody is disabled. Under the Equality Act, we've got definitions, which is one of Section 6, and it says if you have a physical and mental impairment and it has a substantial or adverse effect on your day-to-day activities, and it's all broken down, so that's just the overall of it. In that kind of scenario, you've got people in your workforce who could be disabled, and when you've got somebody, let's say for example, being signed off, let's say with anxiety and depression, and the employer's just, to be honest, ignoring it, going okay, and then they get fed up because the person doesn't come back to work, and then they just sack the person. I've seen practices like that, where they've not got occupational health, where they've not even spoken to their employee about, okay, well, what's going on? They've not even considered whether there's a disability. So there's those practices. I see a lot of a massive lack of support as well in mental health. I'm not going to go into, but a lot of that, and especially during this COVID period. I see, what else do we see? Ignoring of actually sexual harassment allegations. Without naming, obviously I can't because of confidentiality, but I had an inquiry this week itself from a young lady who works for a well-established corporate company, and she no, actually I take that back. It's if I say too much, then I might give it away. I'm not going to go into that.
Be careful.
Yes. And these incidents. So I started asking her, okay, tell me when it started. When did these things start? And if somebody within her workplace that's harassing her, and it's very open, and it started something like 2018. And it's been going on and it stopped, and then it's been going on and it stopped, and then it's been going, and until eventually a third person now from this male's home environment has turned up at this young lady's home, which has resulted in her going, I'm going to need to report this to the police, I'm going to need to do this. But I asked her a very crucial question. Did you tell your employers about it? She said, yeah. She said, I told them back in 2018, 19. They did nothing, just brushed it under the carpet. I told them again. I told them that I was getting emails, and they just ignored it. And now it's come to a point where everything's hit the fan, and this young lady has a very legitimate claim for sexual harassment, but the employers just pulled a blinder to it.
So something like that, how costly potentially could that be for the employer?
It could be, a cost of 50k upwards.
Yeah.
In terms of you've got compensation for her, the intrusive feelings aspect, the relationship is so destroyed, so the trust and confidence is so bad that you've got a loss of earnings claim. You then got the legal costs. So if you go to an employment tribunal, you don't recover your costs if you win. There's a whole there's a massive misconception that you can go to court, you win, and you win your money back. You don't. So you have to bear your own fees. So you could be looking at, if you've got a 5-day trial, let's say, for example, as a minimum, or a 10, you're looking at 12K just for hearings. So it can be very costly to an employer.
Okay.
A very expensive mistake.
No, and you're right. It is. One of the things that I hear a lot about, or scenarios that I've come about through my experience, is an employer will say, look, part of my defence of a decision that I've made, I haven't got it documented. It's been through a conversation, or we've had numerous verbal conversations, and it was well known that this employee, she knew that through this conversation we've said this. Nothing's documented, but basically a decision's been made, but they can't evidence it in black and white. How would an employment tribunal look at it like that? Where does an employer stand in that basis to kind of defend something?
Okay, so a tribunal will start at the point of, they would look at credibility. That's one of the starting points. So they would listen to, obviously, the employer version, and look who's telling the truth. But there are some factors, in my opinion, that a tribunal would look for. If you've got an employer with a HR person in the company, or some sort of support in that sense, you would expect to see some documentation, because it's not like you've got a one-man band. It just depends on the company and the size and who's in it and how the structure is and what kind of hierarchy of people there are. So I'll give you an example. If you've got, Mr. Hussein from the local newsagents, right, who has no structure around him, no HR, obviously, and wouldn't have quite the knowledge, then that's going to be, in my opinion, a credibility, one person's word against another. But then if you've got, let's say, for example, I'm going to use Wildings, we have some structure in place. Wildings isn't the best example because we're lawyers. But let's say, okay, you take a firm of accountants, and they've got, let's say, payroll stroke HR. They've got a bit of structure. There's a managing director, there's supervisors. Then you would expect to have some sort of structure in place, because there's the resources and, more importantly, the knowledge. Because you would expect, that they would know, if we're having a conversation, we need to document it. If we're doing something, we need to write it down. So I think it turns on the company, the structure, the credibility. But unfortunately, we see it often again where businesses, even of a good size, don't have the documented paperwork in place of a conversation, of a resignation. And I'll give you an example. I work with a couple of businesses, and they were going to go, the two members of staff, and they were going to go through one was going to go through a capability, and one was going to go through a conduct dismissal. Fortunately, or for them, as soon as the letter was sent, they resigned. So my questions were, did they put it down in writing? No, we had a conversation. So I ask these lot to now make a note in their diaries of when the conversation, what was said. But not only that, it has to go further. So, for example, I said, have you sent out an acknowledgement? Let me know, what we need to do, because I can draft the letters. You need to just have it. So you've got the paper trail there. And I think it's training these businesses and individuals to a mindset that with any action, there's a consequence. So be it as trivial as the action is, there's going to be a consequence. So you need to do a letter, or there's some sort of follow-up with everything, unfortunately, that happens with concerning staff. So, change of hours, for example, that's another one that I see often. They agree a certain number of hours, then there's a disagreement over, actually, no, you agreed this and I agreed this. So again, what you would do is change of hours, you would document it, and do a variation. It's a very short letter.
See, in our world, we always say, look, it's a very short letter.
Yes.
But the reality with small businesses is sometimes that short letter, that small letter doesn't happen. But what about things like, okay, if we ask the question, what's documented?
Yeah.
And in modern day, it's stuff like, well, okay, I WhatsApp them, or there's a text message, or there's an email.
Yeah.
Those sort of things, does that count?
Yes. I think, look, it's better than nothing, isn't it?
Yeah.
And this is the point. So, look, we know, and tribunals know, that, everything is done, we're so forward in our technology, like, WhatsApping and texting and emails and, voice notes and that kind of thing. My advice is, ideally, if you could do it in a email is fine. Do you know, actually, if you did it even in an email and put that email on the person's HR file, great. But that's better than nothing. So, often cases are actually won by sometimes what's in the text messages or what's in that voice note or what's been recorded somewhere else and not on a formal letter-headed letter. So document it in some way or some shape or form.
Okay.
Yeah.
Okay. Interesting. What's tell me a case without obviously going into specifics so that we can identify them. Give me an example of what was like unbelievably bad and something that was very, very good that a business implemented.
Okay. Something that was very bad, I would say. Okay, I've got an example. So, this was a case where a lady with a disability was off work for a fair period of time, and and there's no dispute around the disability bit because there certainly is that, and the employer had tried to arrange a meeting a few times and it didn't happen, and eventually she did come to the meeting, like a welfare meeting. But she came to him, and unfortunately his office didn't have, so she had a physical impairment, so the office was on a first floor, so he ended up conducting the office in somewhere which wasn't obviously in a vehicle. So he did the meeting in the vehicle. Now he says that was at the request of her. I'm not quite sure that was the request of her. And so there's a dispute around who dismissed who, you see, because he says she resigned because she was gonna unfortunately run out of sick pay, and she resigned because she wanted to get state benefits. She says he sacked her. So unfortunately the
and I take it either party,
yeah,
other than just verbal understanding, wouldn't have anything to substantiate the claim. There's nothing documented.
Okay, so,
or did any party have something in favour?
Okay, so this is where it gets even more interesting.
Okay.
There is on her part there isn't any documentation or messages or anything. On his part, what he has got is a witness, and I'm just wondering, yes, there's a witness, there's a couple of witnesses potentially who I've not interviewed yet, but I question, and I don't even really care because it's the credibility of those witnesses at this moment in time until I interview them. Yep. But unfortunately, there's another case with this individual as well. So he's actually got two employees, unfortunately. And the other case, again, I question the credibility of some of the documentation without going into any significant detail. So I've got some grave concerns about what the end result is going to be. And the reason why I say this is, this individual employee has been very firm in her pursual of the, in the way that she's pursuing this claim. not represented. So I wonder sometimes whether, it's this whole justice, I want justice over, and I will see it to the end.
Yeah. An employment tribunal judge.
Yes.
Now, sometimes we know
Yes.
that an employee is just trying it.
Yeah,
we just know that this employee just sees an opportunity and is looking to grasp it. And we know that the employer's just probably been a bit naive or, just made a bit of a blunder or whatever, but genuinely didn't want to mistreat or whatever.
Yeah.
Does an employment judge look at it that way? Or does the judge take away maybe personal feelings and will just then look at the hard, cold, black and white facts?
I think the answer to that is, look, if you've got, and we've seen this where we've had a former employee present a claim for £250,000, from a very, from a job that paid national minimum wage.
Yeah.
So, and a judge is going to look at that and say, if this is ridiculous. I'll give you an example. I had a hearing in front of a judge, a preliminary hearing, and my client wanted me to produce this overinflated, schedule of loss. And straight away, it was a preliminary hearing. It wasn't even to decide, the merits or the outcome of case. And, the employment judge in Birmingham actually said, Miss Afzal, your schedule looks very much on the high side. If you're realistically trying to resolve this or have some sort of mediation in the future, etc., you might want to have a look at this again. So the judges know when someone's trying it on. The judges know. I do believe that they are trained enough and experienced enough to spot the vexatious or the claims that have no merit. But what our court system will do, Umar, is give that employee the opportunity to put their case before the court. Unless there is something very obvious where the judge might need to deal with it beforehand to strike it out. I mean, in my experience, I don't see a lot of strikeouts from claims that don't have any merits, but I do see strikeouts from failure to comply, or the claim's been submitted late, or the disability where there isn't a disability, but the judges then address that point of a disability from a hearing. So judges, I think our process allows the person the opportunity to bring their case, because it's this, balance of power that we always hear about. I mean, I've heard this word when I was doing my master's as well. Tribunals want to try to have a balance of power between the employer, because the employer is always seen as the superior, stronger person with the deep pockets. So they want to give the employees the chance or the opportunity to bring their case. Okay.
One last question.
Yep.
How do employment tribunals look at when, let's say, the arrangement's a bit of a sham between an employer and employee? And I'll give you an example.
Yeah.
I've seen it a few times with SMEs where they will write a letter to an employee and it will outline, this is your job, this is your XYZ, blah, blah, blah. They probably need that for, let's say, visa purposes to bring a partner over, or they might need it to show their bank for a mortgage, etc., etc. So, you've got something in writing that's a bit of a sham, or a contract that is, look, we've just ticked the box, but then the actual physical relationship itself is just totally different, right? But then later on down the line, whether they've been dismissed or whether they've left or whatever, and then the employee then brings their claim based on, let's say, a piece of paper that is generally a sham. Okay. How would a judge, what sort of scenarios would that be? Obviously, in an ideal world, the employer should never have done that, but we live in a world where sometimes you do it at the goodness of your heart. You think that you trust an employee, that you want, you do it, but then it can go sour very quickly. Where would a judge look at in those sort of scenarios?
Okay, so the starting point, obviously, and this is again my opinion as to what I think an employment judge will do, the starting point has to be that piece of paper or that document, because what you are saying is that document is fake. Yeah. So you've got one party saying that document's real, the employee, and the employer then saying no, that document's fake. But the problem is that document's produced by the employer.
Yeah.
Isn't it? I have found in my experience, whether it's tribunals or county courts, that they are less reluctant to say something's fake or fabricated, because you really need some really good evidence to rebut that. I often hear claimants, and I had a case recently where the other side, another big corporate chain, and this guy ran it all the way to a final hearing, and when he was given the bundle, he pulled in the bundle. He said, this is fake, Neelam, this document's fake, this document's fake, this document's fake. Now you're saying that this big corporate has faked or fabricated documents is a really, really difficult argument to run. The same would apply to an SME to say that this document is really fake and fabricated. Is a difficult argument to run, because the tribunals really have to go, there has to be something more than that for them to do that. Okay. So the starting point is, it's really difficult to get away with saying it's fake. But if there is evidence then to show that it's fake, then the tribunal certainly will consider that, and then they will look at, if you put some doubt, I would say, into the tribunal, that the judge's head, or you could show something to show that document's not genuine, then I think that from that point the tribunal judge will start to look at the reality of the relationship. And tribunal judges do look, we've got something, there's another aspect to consider which is slightly different, is this whole thing about the nature of a relationship. For example, is somebody self-employed, are they a worker or the employee? There's a number of cases around this where tribunals have documents in front of them, like a contract of employment, but the tribunal judge will go further to look at a case and the facts, and with the control element and the mutuality obligations, all of those legal tests, but they will look at the real nature of the relationship and not what's in the document. The two scenarios they've got to be distinguished, because the first scenario is about a fake document. The second scenario is a document that's there, but they go beyond the reality of that wrong document. But I think the answer has to be that it's really difficult to rebut that unless there is some real evidence to show otherwise.
Okay. Going back to suits.
Yes.
Everything in suits was all about let's settle. Yeah. Very rarely did they want to go to court.
Of course.
So what would now, is it more cost effective for a lawyer to go to court or settlement, or what would you say?
Right.
From an SME point of view, is it always better to settle or take your chances to court?
Let's answer this a couple of questions. There's quite a few questions in there, actually. Yeah. So from an SME point of view, yes, of course it is. So, it's better to settle. It's better to settle early. If you feel as an employer that you've not done something that you should have done, or, and I say this very loosely, the commercial aspect, because there's a commercial aspect. As a lawyer, I trained, yes, okay, it's great to settle, but there's also a commercial reality to everything as well. For example, it might cost you 10 grand to pay your lawyers, I'm just saying hypothetically, to go to an employment tribunal and defend that claim, and you've got your ego about it, and because there's so much of that, like but that employee might be asking for, let's say, 5k. It just doesn't make any sense. You would settle, but you've also got this other balance of it, because as an employer, when do you go enough's enough and you start to, if you settle somebody's today at 5, then you settle somebody else tomorrow at 5, because of the commercial reality, then there comes a stance when you say, okay, no, claims have to be defended. But I would say that, unfortunately, if there are any failings, if you've not done what you're supposed to do, then do really think
case by case, isn't it? Then
case by case. But from a lawyer's point of view, no, it's not great to settle, because obviously, as a lawyer, the longer the case goes on, the more fees we get. But we encourage settlement, and you're smiling, but we do really encourage, because I do these fixed fee packages for employees to encourage that settlement. One of the things I will say, and I'm very passionate about this actually, is I see a lot of employees as well as employers, and it's very emotionally difficult for employees to run a whole case from beginning to end to a trial. And it's very emotionally damaging for them already as well, because remember, there might be some serious issues that are there for them already, and they're in a really, really desperate situation. Like, I have sat and listened to so many employees talk about wanting to commit suicide, or actually that their whole life has been destroyed, or their marriages or relationships have been destroyed. I have family members, like I've got at the moment a sister talking on behalf of a lady talking on behalf of a sister, because a sister physically is just struggling. So I am that kind of lawyer where I don't want to run a claim just for the sake of making money, because because I'm not giving the right advice. My advice to them and to any of them is try to settle. So we do these without prejudice letters, try to settle, put forward proposals, and we're proactive. We pick up the phone to the company and HR and say, come on, look, let's have some dialogue. There are some genuine claims here.
Yeah.
We'll see you in court in 12 months time or 18 months. Do you want to do that?
And I think that's the thing, isn't it? There is such a long waiting.
Yes.
And on average, you're looking at, once you put a claim in, 12 to 18 months before it really gets to court.
We've got cases being listed for 2023.
Okay, well,
So,
and is that just because of the sheer volume of people, or the resources?
COVID, resources, everything's like impacted, hasn't it? It's a bit like the petrol station scenarios right now. I mean, that's
just because people are dumb.
but obviously, I think people have gone to another level. But it's the same, like for example, I would say Brexit, shortage of drivers, immigration, supply chain. It is the same with employment. It's unfortunately, issues all impact, and then it becomes, and it's the same with the employment tribunals. That's what's happened. Okay.
Closing.
Yes.
If I'm an SME,
yes,
and I've just listened to all of this,
yes,
I don't have, let's say, legal cover or anything like that. What steps should they be taking in place to? You can never bulletproof not going to a tribunal, because it's free for an employee, whatever. Yeah. But what steps could they take to be in the best situation to at least defend a claim?
I would say make sure that you have some sort of resources, like processes, paperwork, something. I would also say there's a lot of things out there at the moment which have always been there, insurance cover, support, legal support, HR support. Go and get it. There's this massive illusion, and I'm going to say this, that people think, and SMEs think, oh, do you know what? It's expensive. Getting that support is expensive. Going to a lawyer or HR is expensive. It's not. It's actually it's a nominal payment. To be honest with you, depending on different schemes people offer. Go and get the support. Go and get the resources. And if you're going to be so stuck in your own ways and you're not gonna go and get those resources, there's stuff that is available online from credible places. Please don't go to, I've heard so many people go to read all sorts of stuff and come back to me and say, I'm like, where did you read that? It's so wrong. Use credible resources.
ACAS?
Yeah.
ACAS, we can vouch for ACAS.
Yeah. Use ACAS on the Gov site. There's two things that actually, there's plenty of information that might not give you the answer to your particular, but it will give you enough guidance as well to kind of not get it badly wrong. So yeah.
Okay. When will we see your law firm with Afzal on there?
Oh no! Do you know what? I will say.
Would your name be first, or would your other partners' names be first?
I think my other partners would be crying first. Listen, I've got two male partners, right?
Yeah.
I would say would definitely want. Well, I'd certainly one would definitely want his name before everybody else's. But look, I would say this, that Wildings has been established for 30 years. So you know what? It's it's had many partners before, and no doubt, when our reign finishes, somebody else, will come. I hope it's around. And it stood one of the things that's really, really important is that it stood the test of time.
Mm.
So for 30 years, it's gone through, you've seen the recession, you've seen COVID, and this is one of the things I'm very proud of, that the name has stood the test of time. So for me, it's where I'm at, it's Wildings. There's no Afzal and Co coming. But there might be other projects, other incentives, other things.
Okay. Before we wrap up, Neelam, how can people contact you if people want to know more about you? I mean, firstly, social media.
Yes.
How can they contact you?
So, first of all, Wildings is not in Alum Rock; it's in Hodge Hill.
Alum Rock East.
We're in Washwood Heath near the Fox and Goose. That's where you find the firm. The other way is the contact number, which is 0121 786 2555. And if you're looking for me because you want to come and talk to me as an employment solicitor, I am on LinkedIn, I'm on Facebook, I'm on Twitter, and Instagram, but you'll find me in...
So on LinkedIn, they can find you, Neelam Afzal.
Yes.
On Facebook, Neelam Afzal.
Yes.
Do you know what your Twitter handle is?
HR_employment.
Okay, so that's at HR_employment. And Instagram, I take it you're
My
as
name.
Neelam
Yeah,
Afzal
but
as well.
contact me through LinkedIn, and that's the best way.
Okay. Neelam, thank you very much for your input and your insight today. I'm sure it's going to be very, very valuable. Really, it is the worst case scenario for any business, but especially if you're an SME business, to end in an employment tribunal, like you said.
Yeah.
It's stressful, it's costly, it's resourceful, intensive.
Yeah.
It could potentially be the end of some businesses when you look at certain payouts. Certain fees, certain cases are uncapped, and if you haven't got the right cover, it can be the end of your employment. So, end of your business. So, absolutely, thank you very much. I've enjoyed it today. No doubt, as this podcast grows, I will have you back. Hope you will be.
Can I be the 20th?
Do you want to be the 20th as well?
Yeah.
Okay.
Or should we say the 100th? Let's do this, right? So
let's come back on a landmark. Let's not put a pressure on a number on it. Don't put that pressure on me yet, sort of thing. But yeah, no, thank you very much.
Thank you.